My dear friends, my colleagues in legal profession and also fellow citizens of this country, today I would like to share my views on the new criminal laws which are slated to come into effect from 1/7/2024. These new criminal laws needs the implementation of these new criminal laws needs to be put on hold at once. That is the subject on which I would like to share my views. The new 3 criminal laws named as Bharatiya Nyaya Samhita 2023 BNS, Bharatiya Nagarika Suraksha Samhita 2023 BNSS and Bharatiya Saksha Adhinayam 2023 BSA, which are to be replaced Indian Penal Code 1860, Criminal Procedure Code 1973 and Indian Evidence Act 1872. And these 3 new criminal laws are coming to effect from 1/7/2024. These legislations, which are called as revolutionary measures replacing the criminal laws, existing criminal laws, with the proclaimed objective of the present Modi government to decolonize the colonial laws. But the fact is that the new criminal laws are turned out to be a old wine in a new bottle, without any substantial change in most of the provisions of the existing criminal laws, namely Indian Penal Code, CRPC and Indian Evidence Act. Under the guise of decolonization or departure from colonial legacy, the new criminal laws were turned out to be more draconian, stringent, against constitutional democratic ethos, trampling upon the fundamental rights of citizens instead of making improvements in tune with the changing times for speedy dispensation of justice. Of course, there are certain technological progressive steps in the procedural and evidentiary aspect in BNSS and BSA. Basically, the legislation relating to these 3 criminal laws was not put for debate or discussion and to ascertain the public and expert opinions before introducing the bills in the parliament. The existing criminal laws, such as Indian Penal Code, Criminal Procedure Code, which came into force more than a century ago and withstood the test of the time and became most familiar and popular, despite government claim of redirecting the reforms. But the new criminal laws make legal experts and legal fraternities skeptic about their efficiency. Most of the provisions in the outgoing laws are retained. BNS, which is BNS, the new legislation, has got 83% match with the earlier Indian Penal Code. Likewise, while the BNSS, that is the corresponding to CRPC, has got 82% match. And with the other Evidence Act, BSA, it has got 83% match with the provisions of old Indian Evidence Act. Bharatiya Nyaya Samhita, BNS, which will supposedly the what I can say that the replaces the old Indian Penal Code IPC in 1860, featuring 358 sections. And now the new law, it is featuring only 358 sections, down from IPC's 511 sections. It introduces 20 new offences, hikes prison terms for 33 crimes, raised fines for 83 offences, and imposes mandatory sentences for 23 crimes. Notably, the community service becomes a penalty for 6 offences and 19 sections were abolished. stringent penalties for sexual offences, including up to 10 years for deceitful promises of marriage. The BNS also severely punishes the organized crimes such as kidnapping, extortion, and trafficking. Terrorist activities and mob lynching based on discriminatory motives face harshest punishment, including death or life imprisonment. So, the claim of the decolonization is rather hollow than reality, except for changes of names, which again given rise to strong suspicion, imposing a Hindi hegemony in a native of many languages. The substantial provisions more or less remain the same in 3 new criminal laws. In fact, these changes would have been brought in by amending existing laws instead of repealing and replacing them with the new laws with such ado much ado about nothing, and some duplications, as well as creating confusion and defying the logic. For example, BNS 2023 punishes a terrorist act. The definition of the act is exactly same as are provided in the Unlawful Activities Prevention Act, UAPA, a special legislation to deal with terrorist offences. In both, there is no difference in the elements or ingredients of the offences, but here the different provisions but have different provisions and procedures attached to them, and a person is governed by either the procedure under the BNSS or under the provisions of special laws, EAPA. It is very dangerous and peculiar situation where you now have what was meant to be a special law now is being made a part of ordinary criminal law. Thus, instead of a genuine transformation of criminal justice system, and instead of dismantling the colonial legacy, these new criminal laws perpetrate it by expanding the state or government control by retaining the vague and omnibus provisions and widening the police powers, thus failing to fundamentally reform criminal justice system, and instead institutions and these laws are reduced to be a merely repackaged versions of the old laws and their procedures. The reforms fail to challenge the retributive and perpetual centric nature of current criminal justice system, thus missing a crucial chance to create a more transformative just legal framework. As briefly explained above, the new criminal laws not only fail to reform the existing system and laws, instead made it more stringent, retributory, and draconian, adversely affecting the people's right to fair trial and justice. Now, at the outset itself, the very nomenclature of these criminal laws is confusing, and most of the legal fraternity are not able to pronounce these names of these criminal laws. And so, as all of us are aware that the language of the country is English, legal education is in English, and the language of the courts is English. And yet the nomenclature of these laws in Hindi, which is highly difficult to use or pronounce. The whole issue was considered in a narrow-minded thinking, ignoring the basic and well-known principles of usage and difficulties, gives an irresistible impression that Hindu hegemony is imposed on the people of a diverse country, leaving common language English, which has been over the years gone so deep into the system where judges, advocates, police officials, and public at large have become familiar and accustomed. So now they are now left in the lurk, which will lead to chaotic situation in the daily functioning of the courts. In fact, recently, one judge of Madras High Court openly said that it is very odd and difficult for him to pronounce the new names which are in Hindi of these laws, and he declared that he will only use old names in English as IPC, CRPC, and Indian Evidence Act. These new criminal laws also contains more draconian provisions under the guise of reforms. Section 187 of BNSS corresponding to the 167 of CRPC. I'm not able to pronounce it properly. Please kindly excuse me. Allows police custody beyond 15 days of arrest, which is patently unconstitutional. Section 187(2), Class 2, permits police custody at any time, driving out the initial 60 days for severe offences and 40 days for other offences, a radical departure from Section 167, Class 2 CRPC, which says police custody has to be sought only within 15 days of the arrest. Giving such long rope to the police will have serious consequences leading to custodial harassment, atrocities and torture. The police can't be given such wide powers, which is worse than third-degree methods of investigation and blatant violation of Article 21 of the Indian Constitution and nothing but a form of legislative terrorism. Likewise, under Section 113, Class 3 of BNSS, handcuffing of an accused is permitted in certain class of cases, which has been held as inhuman and against the Constitution and held in Sunil Batra and Prem Shankar Shukla case in 1988. Further, under Section 11 of BNSS, solitary confinement of a petitioner or prisoner is provided, which was held to be barred in the above judgment. Amen. Another punishment, that is community service, which is provided under Section 4 of BNSS, where it is defined, and it may lead to very dangerous trend of imposing punishment in humiliating and undignified manner, say cleaning of public toilets or streets, which is against an individual dignity. Introducing parallel procedures and punishment for the offences which fall under special acts such as organized crimes, which is an offence under special law, MACO, MACOCA, TADA, TATA, terrorist activities, and POTA Act for terrorist act. Introducing Section 111 for the organized crimes and under Section 113 for the terrorist act, which result in conferring jurisdiction in the hands of local police, is bound to result in nuisance and double jeopardy to the accused. So also the provisions, Section 106, Class 2 of the BNS, providing enhanced punishment in motor accident cases, is too harsh. Notably, Section 124A IPC, the sedition law, is under judicial scanner, and the Apex Court on 11/5/2022 ordered that the provisions be effectively kept in abeyance until the union government reconsidered it and directed that the union and state governments to refrain from registering any FIR under Section 124A IPC for the offence of sedition. Yet, the government added Section 50 in the BNS that criminalizes act that endangers unity, sovereignty and integrity of India by replacing Section 124A, which has much wider and enlarged implications, giving unbridled powers to the police, which causes alarm to the public. Of course, there are some good and useful provisions, like mandating audio-video recording of police searches, forensic evidence collection, and settling timelines, a period, setting timelines for investigation or trial proceedings. But there is the corresponding institutional capacity to implement these reformative measures. There is no corresponding institutional capacity to implement these reformative measures. Even the Honorable Chief Justice of India, Chandrachud, while addressing a conference on 24/2004, underscored that the new criminal laws will only bring positive changes if the required infrastructure development and the capacity building of forensic experts and investigating officers are made at the earliest to effectively enforce these reforms. This means that the government must heavily invest in capacity building of our forensic experts, conduct the training for investigating officers, and invest in our court system. These key provisions of the new criminal laws would only produce a positive effect if these if these improvements are made as early as possible. CJI further emphasized, he also cautioned about Section 5 to 22 of BNSS, that is corresponding to CRPC, which allowed all trials, inquiries and proceedings to be conducted electronically. But it is very crucial to protect the privacy of victims and as well as the accused, which is a fundamental right guaranteed by the Constitution. Further, the government has not bestowed its attention towards preparing the criminal towards the pendency of the criminal cases, running into not only thousands but lakhs of cases right from the trial court to the apex court, which takes so many years to dispose of in accordance with the old laws, as these new laws, the criminal laws, have only retrospective effect. So we will have two parallel criminal justice systems for a foreseeable future, which may range from 20 to 30 years. The government failed to conduct any study as to the impact of these new criminal laws on the backlog of cases which are already pending for trial at various stages, and no discussion in this crucial aspect seems to have been conducted by the government. All these factors makes us to believe that the government, central government headed by Modi, has not diligently acted in rushing through these new criminal laws without any debate or discussion in the public domain. The manner in which these bills were bulldozed in the parliament smacks of suspicion of the government intentions. These bills were not put for discussion in detail even in the parliament and passed in authoritarian and hasty manner amidst the suspension of almost 146 members from both houses of parliament on 2012-2023, as rightly pointed out by the main opposition Congress party and other India partners and other opposition parties, and also the West Bengal Chief Minister Mamata Banerjee. Yes, there are wide-ranging reservations and apprehensions in the public minds and in the public domain regarding these laws. Neither they were put to discussions in the parliament nor placed before the public, particularly before the legal fraternity, to get any proper feedback. Even after fractured mandate in the recent elections, Modi government has not learnt lesson and not to be authoritative to implement these new laws, which will affect and endanger the very fundamental rights of citizens. The Law Minister recently declared that these laws comes into force on 1st July 2024, notwithstanding the stiff opposition from the people, legal experts and opposition parties, which is nothing but arbitrariness and totally despotic. It is not too late even now for the Modi government to respond to the call of the public and put the implementation of these new laws on hold, postpone the same until all stakeholders, including judiciary, legal fraternity, investigating agencies, state and central union governments, and other departments and citizenry at large of this country to have an opportunity to debate and discuss about these laws and also place it before the Parliament for reconsideration of all the provisions for a pragmatic assessment of challenges in implementation of these laws and its implications on the public access to justice and criminal justice system. So, the central government must immediately halt the implementation of these three criminal laws at once and put them before the Parliament and also public domain without taking any unilateral and arbitrary decisions. Laws must be people-centric and not political and ideological centric. The opposition parties, more particularly the NDA coalition partners, senior partners like TDP and JDU, headed by Sri Chandrababu Naidu and Nitish Kumar, must make this government to bow to the public demand and prevail upon it to stop the implementation of these criminal laws pending the detailed discussion. I hope the entire legal fraternity also stand as one in opposing these criminal laws and put pressure on the government to reconsider the same. Thank you very much. Jai Bhim, Jai Bharat.